All right, good afternoon, good morning, good evening, wherever you are joining this conversation from today. I welcome you to this special edition where we are going to be discussing the reality of our moments about artificial intelligence. And we want to look at this conversation relating it to the subject of copyright. How do we connect copyright when it comes to artificial intelligence? And today we are going to be looking at ChatGPT, which has been trending. ChatGPT. If you are yet to check ChatGPT, maybe you use Google to check ChatGPT. And at the end of the day, you might find that you fall so much in love with it. And ChatGPT creates a lot of content. It's one of the things we want to talk about in today's conversation, because you would find that those contents they are powerful. It's creating job for other people, and is sending many people out of job. For instance, many people that would have said that they are expert copywriters. The question is, would they be better off compared to what ChatGPT will do? These are some of the questions that we want to look at in today's conversation. So the topic I'm going to be considering in this session is the question: who owns the copyright in artificial intelligence assisted works? I'm going to be using the word AI to depict artificial intelligence a whole lot in this conversation. Who owns the copyright in AI assisted work? So first, let's start with the question. So what is artificial intelligence? I'll try my best to break all of these things down so that you can have a feel of what we are really talking about. Now, imagine places and subjects where there would have been a need for some human intervention. And imagine now leveraging on tools like software, tools like computer program, and all of those things. Imagine leveraging on those tools to get at least exactly or about the same results that human intelligence would have gotten for you. This is what AI is all about. And today, as I mentioned earlier, we want to really dig down deep into ChatGPT. Again, you need to check ChatGPT to really see a whole lot of things that it can do. So, what is beautiful about ChatGPT? One of those beautiful things, so ChatGPT is an example of an AI-powered intelligence. And why do I call it an intelligence platform? I mean, an AI-powered intelligence. Now, ordinarily, human efforts through people, so you could say copywriters, you could even say composers. So through human efforts, people could compose a whole lot of things that are subject matters of copyright. So that would mean that like I want to compose music, that would be my intellectual effort. I want to compose a poem. That would be my intellectual effort. I want to compose or even author a book. That would be my intellectual effort. A whole lot of things I might want to do will come from my intellectual effort. But where ChatGPT comes in is that it could really, based on the instructions given to it, create all of these things that we have talked about, and what more, even many other things, thousands, hundreds, and millions of other things that we may yet still be unable to even comprehend, depending on how it is programmed or the input that is given to ChatGPT. And take this classic example. Here's my book, Structure secrets for startups. I decided to use ChatGPT, and I gave a prompting to ChatGPT, and I said, can you transcribe my book, Structure Secrets for Startups, to French? So I decided to put in the English version of my book, and voila, it came out with the French version. Can I just do a download of this content and then decide to have it printed and expand my market reach for this book to France and many other French-speaking countries? You said, wow, there. That was what it was like for me as well when I made that attempt on ChatGPT. So ChatGPT is an open, is an AI software that does a whole lot of information in a way that is even conversational. So you can engage with it and without even mentioning any form of technology that we used to know until now. So let me just get into it now. Ordinarily, if you want to do a search, you go on any of these search algorithms, any of these search sites, and then you input information, and then there is an output. Now, that output is not in any way conversational. You still have to dig, bring information together, and then express your thoughts. That was the state of art that we used to know. But what ChatGPT, among other AI-powered solutions, have done is to then create a platform that is conversational and is able to put thoughts together in such a way that you don't even need to stress yourself. Let me give you a cheat sheet here that many people are using, but there are questions around all of these things. For instance, it is the impression out there, or better still, it is the reality that a number of students are beginning to leverage on ChatGPT among many AI-powered solutions to get their jobs done. Don't be shocked that this is not just a student thing. It is also a lecturer thing. So a number of lecturers are also leveraging on this kind of solutions to put together their content. And the question you then want to ask is, so in this situation, who owns all of this content that are being disseminated or sent out to the public? The interesting question is what we really are trying to look at in today's conversation. And I'm going to be looking at this I will attempt to answer this because I see that we have a spread of audience across the globe from different parts of the world. So I will attempt to address this conversation looking at least 4 different countries. In other words, 4 different jurisdictions. I'm going to be looking at what is the current state of things regarding AI and the issue or the question of copyright in AI-assisted works when it comes to the United States of America. I want to look at what is the situation in the United Kingdom. I want to look at what is the situation in the People's Republic of China. And of course, I want to bring it back home to look at what is the situation in our country, Nigeria. And these are the 4 places that we are going to be considering in today's conversation. But on a general note, I want to throw a question to you, and I need you to get to the comment box. Let me hear your thoughts around what you think. Generally speaking, you might agree that ChatGPT, among many other softwares or many other programs, is a product of certain programmers, or at least a programmer. So somebody must have been behind that structure, so to speak. You might also agree, if you have used ChatGPT before, that it needs to be questioned, or you need to impute information, and it is what you impute that will determine the output, what you get. So that's the user factor. And then you might also then want to look at it that ChatGPT itself is a software. It's in a fixed, definite form, if you want to use that word. So the question then is, who do you ideally think will or should own every expression or any expression that comes from ChatGPT? Do you think it should be the programmers that designed ChatGPT? Do you think it should be ChatGPT itself because it really has been designed and it's the one that is doing the job? Or do you think that this should be the user, that is, the person that imputes the information and guides the output that comes from ChatGPT? Or if you want to look at it another way around, do you think that it should be considered for co-authorship? And if you are going for co-authorship, would you be saying that the co-authorship should be a co-authorship between the user and the programmers of ChatGPT? Or better still, it should be between the user and ChatGPT itself? Or maybe it should just be ChatGPT and the programmer? I mean, these are very interesting things that are out there. And I would just love to test your thoughts about this interesting conversation before we really dig deep. The beautiful thing about law, of course, is the fact that there's really no absolute response. Law continues to, we continue to build, and it's a social relationship thing. So most times you'd find that really there is no wrong answer when it comes to law. So I do not want you to resist from sharing your thoughts around what you think about this question I just asked. I'd love to know your idea, and I need you to drop it right in the comment box. Let's get this conversation going, and let's make it as interesting as possible. So I gave the example of my book earlier on, and now I said we are going to be considering the 4 different countries: the United States, the United Kingdom, the People's Republic of China, and Nigeria. And then we can then come to the conclusion on what you think, because at the end of the day, it's still going to be about what do you think. Let's start with United States of America. As recently as between late last year until about last week, we had a robust debate. Something very interesting happened where somebody who has been an advocate of AI, artificial intelligence, wrote a novel, or better still, wrote a comic book, and then used artificial intelligence software to design the characters, or better still, to design the images used in that comic book. And then this book was passed on to the U.S. Copyright Office, the United States Copyright Office, and it was approved. But upon going public to announce the success of being the first AI-generated or AI-assisted work to be copyrighted, to be registered as a copyright, the U.S. Copyright Office then did a retraction. And then the debate, or better still, decided to look into whether an AI-assisted solution or AI-assisted product can actually be copyrighted. One of the very, very crucial questions that came up for the US Copyright Office to resolve is the question of originality. As you might well be aware, originality in most cases, or better still, originality, generally speaking, will presuppose some elements and a reasonable extent of human effort. In essence, originality would mean that as a product of some effort from within a human. Now, it is on this basis, again, that the law in the United States presupposes that humans are the subject matter of copyright. Copyright cannot be given to plant, animal, or even nature. And that reminds me, 2018, there was this very interesting case of Naruto against Slater. That was 2018. And the conversation in that case happened to rest on a picture that was taken by an animal, I think an ape or a chimpanzee in this situation. The animal, of course, got a camera. The camera, whether it was positioned or not, well, that wasn't really the subject matter. But the animal decided to pick the camera and then did a selfie. And this selfie got up out there to the public. And the owner of the camera had made attempts to own the copyright in that picture. And then it became a conversation. Can we say that the owner of the copyright is the animal? Because, of course, it was the animal that took the shot. Can we say that the owner of the copyright is the man, the owner of the camera, because he might have positioned and configured everything around the camera and the output that eventually happened? But the court was of the opinion in that case that there was no copyright in the picture because it was randomly taken and it was taken by an animal, which cannot be a subject of intellectual property protection. Now, I want us to relate this to what we are talking about. I made mention earlier on about, I think you can check out Chris Castanova. Now, this was the person, the character, the person that wrote the comic, and then it became a subject matter, whether the fact that she used an AI-powered tool to generate the picture, the character, whether that fact would then mean that she would not be able to claim copyright, or it's going to be considered, better still, as a derivative work. Now, today's conversation is not about derivative work, so I'm not going to jump into it, or whether you can say that there was really more from her that makes the work to be original to her. And in looking at all of these things, so there are tests that the United States Copyright Office came up with. Three tests, at least from the response given to Castanova on that case when she made her presentation to the Copyright Office. The first test is what I would call the 100% originality test. In essence, even though the work that was generated from the AI tool is such that it was generated, but did the owner, or better still, the person that made the input now make adjustments in such a way that it can be said that the entire content became 100% original without any input whatsoever from the AI-powered tool. Now, this is quite a rare scenario, it's quite a rare situation, but it is also possible because we would find people that would say that, look, I got inspired by what this AI tool gave to me, and from this inspiration, I was able to give birth to an 100% generated solution, or something that is original enough devoid of whatever the AI tool generated for me initially. So this is the first test. Now, the second test you might be looking at is what is called the sufficiency control over the output. In essence, I had to put in my content, the content of my book, Structured Secrets for Startups, on the AI tool. Now, I could give certain level of instructions to ChatGPT in such a way that whatever comes out, will you be able to say that, look, even though this came out from ChatGPT, did I demonstrate a number of things that show that I had control over what ChatGPT eventually presented to me, which is called the sufficient control over output test. And the third thing is what is called the substantial modification, such that it then makes what came out from ChatGPT, it then made it original. In essence, will it be said that having gotten an output, there was a substantial modification? Remember, there was the extreme test of 100% alteration, adjustment. Now we're talking about a substantial modification. So these are things, these are factors that might be looked at, because ordinarily a machine, as far as the United States is concerned, cannot be a subject of copyright. As said earlier on, a machine will not be a subject of copyright, and that includes an AI machine, whether it's a software or a computer or whatsoever it is. It would not ideally be a subject of copyright. So let me try to explain the input and the output part of this conversation, because I said that earlier on, and you really may not get what that conversation is all about. So here's a camera with me. Now, if you check these are functions, and then there is a lens. I could zoom it in and out. All of these things, they affect what comes. Now, as this camera is positioned, it ideally sees things. I could just, try to look in and then take a look at the object I want to capture. And I could then begin to alter things around, change configuration to get something original. I have given some tests here, and I asked the question as well. Let's bring it home using the United States as a point of reference. Will you love to say that what comes from my shot will be owned by the producers of this camera just because they produced the camera that gave the output? Or would you say that it should be owned by this camera? Or would you say that the fact that there was substantial control, I positioned well to determine, right, the best shot, and then I also checked my configuration, my zooming, all of these things added together was what gave that shot. Now, I am still trying to explain, in essence, the context of input and output. To what extent? What's the extent of the input, and did the input affect the output such that it brought out something original? Did you have sufficient control over what came out? And what came out as well, did you make sufficient alteration and all of that? So these are very, very interesting, crucial things that you may want to consider when it comes to the test of who owns copyright, broadly speaking, in AI-assisted works. Let's jump to the United Kingdom because of our time. Let's jump to the United Kingdom. So I hope that the issue of input and output is really, really dealt with. So just to wrap it up again, my book, Structured Secrets for Startups, the fact that I picked all of the content and then put them in and then I instructed ChatGPT to transcribe from English to French is an input. What it brings out is the output. The question again is, will you say that what it brought out is original to me? Right? I still want you to get to the comment box and let me know your thoughts around this. Coming to the United Kingdom, Section 9, Sub 3 of the Copyright and Designs Act of the United Kingdom is very, very instrumental in talking about the issue of copyright and artificial intelligence. I'd love to read that section to your hearing. The section reads that in the case of a literary, dramatic, musical, or artistic work, which is quote and unquote computer generated, the author shall be taken to be the person by whom the arrangements necessary for the creation of the work are undertaken. In the context of our conversation today, and based on Section 9, Sub 3 of the Copyright and Designs Act of the United Kingdom, who would you say owns the output that is generated from ChatGPT? The point is this. As recently as mid last year, the United Kingdom Copyright Office came up with a release on its stand when it comes to AI-powered solutions and works generated or assisted by AI-assisted works, pardon me. And the position of the Copyright Office is to the effect that there may really not be an immediate move to alter Section 9 Sub 3, but that interpretation of computer generated will continue to suffice, perhaps. But I kind of disagree with this for good reasons. I disagree with this for good reasons because this will just lead to judicial activism. This law was made way back when people could not even envisage what AI is doing today. And it would just mean that there is really a need to make some alterations that faces the reality of what AI is able to do today. If we are to apply this provision to what AI is doing today, now let me read this part. It says, the author shall be taken to be the person by whom the arrangements necessary for the creation of the work are undertaken. This might mean the person that programmed the AI solution. This might also be interpreted to mean the person that put in the inputs which generated the output. It's the more reason I said this is going to lead to a lot of judicial activism. So I kind of feel that there is a need for the United Kingdom as an entity, especially now that it's away from the European Union. Now it has to make its own laws, it has to do a lot of things, and this is one of the tests. This is a test of that establishment. This is a test of the United Kingdom as an entity to really, really redefine what it means by, to really do a review of its laws as far as it has to do with artificial intelligence and the reality of AI-assisted works. Let's jump to the People's Republic of China, which is a very interesting place that I'm sure that you want to also take a deep dive into. So, the position in the People's Republic of China, I would want to make reference to a certain case that I think that case happened about 3 years ago. But some of you will know Tencent. Tencent, the people behind WeChat, and a lot of many AI-powered platforms and solutions. And one of those solutions happened to be a solution that, content creation, content generator, and then which moves like it produces content so fast. And then somebody somewhere, when I say somebody, I mean a corporate entity now, had decided to pick one of such content. And Tencent decided to sue, making a claim for copyright ownership in the content. The defense, of course, was that the software is not human, and there was no human effort behind what was generated. And so whatever comes from that platform made by Tencent ought to be considered as something in the public, which anybody and everybody can pick. The court disagreed with that position and, of course, held that Tencent, being the programmer, has a copyright in the program. I leave it again to you to let me know your thoughts, because the question remains, who do you think owns the copyright? The programmer, the user, the program itself, that's the software, or you would rather say it's a co-authorship? I want to leave that to you. Let's bring it home to Nigeria. Nigeria is quite a unique situation. Nigeria is unique because we have really not made adjustments to our law. And you would permit me to read what we have under our law. I must make this confession that, as said, we haven't really made progress on our laws. So if we are to look at it through the books, through the letters of the law, we will be making reference to Section 51 of what is our own copyright law. That section is merely an interpretation section of the law. And that section defines computer programs. It defines computer program as set of instruction to be used directly or indirectly in a computer in order to bring about a certain result. I'll read that again. Computer program is a set of instructions to be used directly or indirectly in a computer to get certain results. And so the question would then be that who is entitled to this? Are we talking about the program itself, which could be the source code made by the programmer, now stated in a definite form, and then it then qualifies as what is called a literary work, which of course is what the law envisages, because the law goes further to classify literary works and include computer programs under literary works. So we would say that if the owner of ChatGPT were to be entitled to some protection in Nigeria, then that protection will be for the source code that was used to put ChatGPT together. But let's do a judicial activism. Let's do a judicial activism on that provision. Now, I wanted to call this a somersault, but let's do a somersault on that provision. Could we say, interpreting again, computer program set of instructions to be used directly or indirectly in a computer in order to bring about a certain result? Could it be said that when I put my instruction together on that ChatGPT, my instruction for it to convert, the result then became something I could say, well, this is an AI-assisted computer program that is qualified for protection under the law? I literally do not think that will flow. And that drives us to one thing. Nigeria needs to begin to look into AI, artificial intelligence, and then channel its own policy so that that industry can really, really be built, especially for the Gen Z and the many other generations coming after the Gen Z, who are the most active within the industry. This is something we should ponder on, especially if you're a Nigerian that is following this conversation. But let's come again to, in closing, what are the take-home points? What are the things that we can pick? For me, and I want to hear what yours is, but for me, I would say that for now and for the future, it matters that there is a full disclosure of any AI assistance that went to any copyrightable subject. A full disclosure would mean I used ChatGPT. A full disclosure would mean referencing ChatGPT. I might have picked the paragraph in ChatGPT. A full disclosure would mean referencing it, the date when I did my check, the link to the results, and many other things. I think it's the first step that we should take, a full disclosure. And then the next thing is, upon a full disclosure, I'd rather see as well that there should be some form of adjustment, some form of review, such that what is coming from ChatGPT can be said to be original to you by reason of substantial adjustments here and there in the content. I think this is also crucial. I would also want to say that there should be a proper recording of what goes into ChatGPT. For instance, I need to also, if it's possible, record my screen and all the facts about, look, what entered ChatGPT was my content. I only requested for an assistance to convert it. I need evidence of all of these things so as to demonstrate that there is a substantial originality in what came from ChatGPT. Again, remember the rule, the input and the output. This is where it matters a whole lot. And I need to record all of my efforts, every of my efforts, just to ensure that there is a level of originality, substantial inputs from me as the human force behind the AI element that is put together to get me some results. Again, I want to hear your view around all of these things. What do you make of ChatGPT? What do you make of AI solutions in assisting people to get results faster and to get results in a very clean way that makes their work look very, very awesome? What do you think about ChatGPT? What do you think about ownership? Do you think that ownership should go to the programmers? Do you think that it should go to ChatGPT? Do you think that it should go to the user? Or do you think that there should be some form of co-ownership here based on the realities and everything that we've discussed? Or perhaps you have some form of other ideas or thoughts around this. Drop your comments and let me know what you think on this conversation. And broadly speaking too, what will you advise people when they are using AI-powered tools to advance their works or to assist them in getting results faster? I want you to drop your comments below and let's know what you think. Thank you very much for joining this conversation. My name remains Eyitayo Ogunyemi. I'm a legal practitioner. I practice in Lagos, Nigeria, and I'm a member of Law Accent with offices in the United Kingdom, in Kenya, and across Nigeria. Thank you for joining this conversation. We look forward to hosting you again